Yeah. I'm going to answer it this way. We haven't seen any like enforcement against people in the United States that are investing in Canadian companies. You can still, you can invest in a stock on the Canadian Stock Exchange, right? There are a number of companies, whether it's Tilray, Canopy Growth, that are public now. There are more and more that are going public in Canada, whether through an IPO or some type of reverse takeover. And so you're going to have, even retail investors here in the United States that are going to be buying stocks, cannabis stocks on those exchanges. So far, there has not been any type of crackdown on that type of behavior. It's still not clear to me that it's perfectly legal, the same way that if I'm in the United States and I invest in a cocaine dealer in Venezuela, right, under the United States federal law, it's the same thing, right? But we haven't seen any type of enforcement or adverse. Oh, I see what you're saying. That's a good question. I guess I'd want to think about that before I spout off. I suppose it's possible that that's something that could be permitted. But the reality is you can have a bank in the United States serving this industry. It's just a matter of the bank being willing to take on the compliance costs. No, there was a case in Colorado from a couple of years ago. I think it was Coates versus Dish Network, or Dish Network versus Coates and Dish Network were the entities. The caption of the case. It went all the way up to the Colorado Supreme Court. It was a state case where there was a guy who I think he was quadriplegic, and he was requesting a reasonable accommodation to use marijuana because he was quadriplegic, and Dish Network would not make the reasonable accommodation. They wouldn't allow him to violate their drug policy. And the Colorado Supreme Court found in favor of the employer, saying the ADA imposes no obligation to accommodate something that's illegal under federal law, which is why where we've seen cases crop up, even in federal courts, they're all based on the particular state law. The Connecticut case was because of a Connecticut statute that protected patients. There was a similar case in Massachusetts. Under Massachusetts law, there were specific patient protections, and we don't have that here in Ohio. So I'm not aware that, number one, there's been any ADA type cases here in Ohio, and I'd be very suspicious that they would succeed. People will try, but I don't know that they have a real high likelihood of succeeding on an ADA claim to get a reasonable accommodation to use marijuana, in violation of a drug-free workplace policy. No, it's not changing. No, it's not changing. Yeah. This blue wave would have to be some wave to get a makeup where that would change. And that was something that was specifically addressed. When I testified on House Bill 523 in front of the Ohio Senate, Chamber of Commerce was there that same day, and I think it was at the time Senator Bill Seitz sort of asked them and said, if we change this employer protection, how's that going to change your response to the bill? Because they were sort of neutral, and they were pretty clear that if there's one thing you want to get us adverse to this piece of legislation, that's going to be it. Good question. Yeah. So CBD is sort of like Schrodinger's cat, right? The cat's in the box. Philosophy major, maybe nobody else gets that. CBD is not one of these products that is either legal or illegal. Its legality depends on which part of the plant it comes from. So you're right, DEA originally, they had this marijuana extract rule where they said any extract from the cannabis plant is a controlled substance, and we mean CBD. So we have this new extract code for CBD. That's how that rule came into being. But they've since acknowledged that we don't have the authority to schedule non-controlled parts of the plant. So that rule is still out there, but they've walked back their interpretation a little bit. The DEA still will seize CBD if it's being shipped somewhere, but we haven't seen federal prosecutions. I only have 5 minutes? All right. But that's why the source rule is important. If it comes from a part of the plant that's not controlled, then arguably the CBD derivative is not a controlled substance. All right, so let's blow through the attorney ethics part, probably one of the most important parts. Originally, House Bill 523 had protections for professionals, and the statute said if you hold a license like a license to practice law, you're not subject to professional disciplinary action by engaging in professional activities relating to medical marijuana. But regulation of the bar is delegated explicitly and specifically to the Ohio Supreme Court. The legislature cannot tell the Ohio Supreme Court when or how it can discipline attorneys in the state of Ohio. So we had to seek an advisory opinion from the Ohio Supreme Court as to what sorts of things lawyers can do in this space with a particular eye towards Professional Conduct Rule 1.2d, which is the prohibition on assisting or counseling clients to engage in illegal activities, and then Rule 8.4, which deals with an attorney's own conduct that might adversely reflect on the attorney's honesty, trustworthiness, or character and fitness to practice law. The rule was pretty clear that you couldn't help clients under Rule 1.2 do anything that was illegal, but you could advise them about what happens if they do certain things. So we submitted a request for advisory opinion, and boy were we unhappy with what the Board of Professional Conduct said, because they were very clear and followed a sort of minority view of Rule 1.2 and said, because it's illegal under federal law, you can't help clients get these licenses. You can't even represent a landlord leasing space to a cannabis company. That's how limited your work was. But you can do some things. You can counsel them about the conflict between state and federal law, and you can represent government entities. They punted on the Rule 8.4 question. We asked specifically about, can a lawyer use medical marijuana, and can a lawyer own or operate a medical marijuana company? And we'll get into the 8.4 stuff here in a little bit. Shortly after that opinion came down, Chief Justice Maureen O'Connor issued a statement and said, okay, that's a non-binding opinion, and we're going to fix it. So we're going to accept public comment on amending Rule 1.2, and they did. They adopted a new section. We asked them to adopt this rule that said a lawyer can assist the client to the extent the lawyer reasonably believes that the conduct is authorized by Ohio's medical marijuana law, and you still have to advise about the conflict between state and federal law.